A will is a document by which you determine who inherits your property and sometimes who manages it after you're gone, how it is distributed to your relatives or friends or whoever you want to leave it with. There are two main conditions for a valid will. One is that you must have the mental capacity. You must know what you're doing. You must be able to make a decision. So if you're in full flight of Alzheimer's, you wouldn't be able to make a will. The second condition is how it is witnessed and so on. A will must be witnessed by two witnesses, and the person making the will and the two witnesses must be present, all three at the same time, and they must each see one another sign and then come to sign in the presence of each other. So you can't do it by round robin. All three must be present at the same time. And as simple as that. You may only have minimal assets, but you may have a share in an estate of a deceased relative. You may have an undivided share of property that you never got sorted out. So even if you have more than one person to inherit your property, it's good to have a will because it avoids questions like that. So that even if you do not think you have a big estate, for certainty and ease of reference, it's good to have a will anyhow. And as I said, you never know what other property you may own that you're not even entirely sure about. Making a will because you want to have gives you control is a good idea. If you do not make a will, the law will dictate who your property goes to, and there are a whole list of rules as to who your property will go to. If you want to be certain that the people you want the property to go to are the ones who will get it, you have to make a will where you can specify those people. For example, it's a common misconception that a spouse, if you don't make a will, your spouse will get all your estate or a significant part of your estate. This is a fallacy because the spouse only gets a small share. The spouse will get your personal property, like your car or your jewelry or whatever, and 1/10 share of the rest of your estate, just a 1/10 in value, not even on the ground, 1/10 in value. So if you really want to provide for your spouse, you have to make a will. Then the will will also say, then the general law will list the people who it will go to. It will go primarily to your children after taking into account the small share that goes to your spouse. If you have no children, it will go to your parents. If your parents are deceased, it will go to your brothers and sisters. If they're deceased, it will go to your aunts. So there's a whole list of, so if you have 6 brothers and sisters, then it's always a battle to, some may live abroad, some you may not have heard from for a long time. They all have to bring their birth certificates and their marriage certificates, and the certificates may be written up with the names spelled differently and all types of things. So it's better to have it sorted out, and so you have that control, and it saves you a lot of time, not you, but it saves your relatives a lot of time and money in sorting it out. That's another big part of making a will. It reduces the confusion, reduces the tension. There's a big scramble for assets sometimes. This person holds on to this piece of land, the other person holds on to another, and it is a mad rush. Or somebody builds on this piece of land and says, I'm taking it because he told me that this piece was for me. But that is a fallacy, that's a mistake. What should happen is that the will sorts out all that confusion. It is clear-cut, a well-drafted will prepared by a lawyer, and in very clear terms will tell you exactly what will happen to the property, who will inherit, and if you want to leave property for somebody who is not a close relative. The will also ease congestion, ease confusion in the sense that it is easier to apply for probate of a will than a grant of letters of administration. If you leave a will, your relatives would apply for what is called a grant of probate. Your executor, the person you leave to manage it, will apply for a grant of probate. If you do not leave a will, your close relatives will have to determine who will apply for a grant of administration. If you have 5 children, they're all equally entitled. They will have to either do it all together, which is difficult if they live different places or if they don't get on, or they will have to select 2 or 3 out or 1 out of the group to do it, and that causes confusion because there's distrust. One takes too long, but if you do, at least appoint an executor and you give that person the power, then there's somebody who is accountable. It is clear who is to do it and who's to take it forward. And the law knows what to do if somebody doesn't take it forward, who to hold accountable. So it minimizes a lot of that confusion as well. How do you look after people who may not be your immediate relative, who may not be inheriting property as one of your children or one of your brothers and sisters? Normally, elderly relatives get left out, so it's a good idea to make a will if you are a certain age and you have relatives who are in their 70s, 80s, or even older, and you want to make sure they're retired people, they're not in receipt of income, they may have health challenges, and the best way to look after these relatives is by a will. Otherwise, they will be left out. If you have children, the property will go to your children. If you have a special cousin or a niece, or somebody who is disabled and can't look after themselves, or you may have 4 children, 3 of them are well positioned and good jobs and can look after one who needs help for whatever reason, you may want to make special provision for that person. Or you may have a friend, a family friend, or a cousin or somebody who would not inherit, and you want to benefit that person, you leave something in the will for that. It may just be a share of money from an insurance policy. It may be a small piece of property, but the only way that person will get it is if you make a will. Yeah, how to deal with insurance policies and so on. You have a will, you may have an insurance policy, and you may not name a beneficiary. You may have a named beneficiary in your life insurance policy, and the property, the money will go to that person. If you don't have a named beneficiary, suppose your policy is assigned to the bank, but it's not named, there's not a named beneficiary who will take it. On your death, once the bank is paid, that money can then be used as a legacy, what is called a legacy for a relative. That's a sum of money that goes to a relative. So if you don't have cash, you can use your insurance policies to pay legacies to people, children who are still undergoing education, for example, people who need hospital care, or for whatever reason. So it's good to still use your will to use the insurance money for legacies. So that's a good source of your legacies in an insurance policy. A good source of your legacies would be your insurance proceeds. Yeah, the cost of the will. A simple will is not costly. A simple will shouldn't cost you more than $500, for example. In that case, you can even do the will yourself if you have, there's certain places on the internet you could do a will. It's simple. I appoint John Smith my executor. I leave this property for John, this property for Mary, this property for Peter, and this property for my parents, Mr. and Mrs. whatever. And then at the end of it, you sign it in the presence of 2 witnesses who are all present. Your major problem with making a will is getting the execution of it right. You must make sure that you sign it in the presence of 2 people who are not getting anything in it. The 2 people who witness it shouldn't be beneficiaries. So you sign it in the presence of these people, you're all 3 there together, each person sees the other sign, and that's good enough. And that's the major technicality with wills. But apart from that, you can draw up the will and you appoint an executor, and you give your property in simple, normal language to whoever you want to give it to. Just get the signing right, but you can do it yourself. Yes, 2 very important points, whether you're locked in and you can amend the will or change it. And a big point which I forgot is the effect of marriage on a will. First of all, if you're locked in, a will is simple to change. You could change your will at any time. It's different from a transfer. If you give your property, it's given and it's done. You can't change it. But a will, you could obviously change it from time to time, tweak it. If you give it to Mary and Mary passes away, then you change the will and give it to Sandra or something like that. So it's easy to change. It's very simple to change. And if you have a word version of it, it's even easier. The other part is whether, to what extent you can, what's the question? Yeah, the effect of marriage on a will. Very important, marriage revokes a will. So if you make a will on the 20th, you get married on the 22nd, that will is no longer valid. You have to redo the will. The same will, you could just reprint it, change the date, and re-sign it again. But just remember that marriage revokes a will. There have been some horror stories where a man wanted to, living with a woman for years and wanted to make things right before he died, so he made a will for the woman, and some children and whatever. Then he got married to the lady, and it revoked the will. So the people who he thought would get it, what he thought he was doing, he undid. So you have to remember that marriage revokes a will, so you have to republish it. If you undo that will, you go back to the position where you, as if you didn't have a will, and the law then determines who will get the will. I think I should also mention that illegitimacy has been abolished, so all children, whilst they can prove that their children will get the will, will inherit property, children born in marriage find it's easier to prove their paternity because they're born in marriage, but children born outside of marriage are just as much the children as the man as any children, once they can establish it.
And that does not apply to stepchildren of the testator?
No, question is whether, when you look at children, whether it applies to stepchildren. No, it doesn't apply to stepchildren, stepmothers, stepfathers, and so on. So if you have a good relationship with your stepmom and you want to make sure she inherits property, you must make a will and include her. And if you have a good relationship with a stepchild and you want that child to inherit, you should also make a will actually naming that stepchild. Yes, you should follow the Money Matters protocols and programs about how you make a will and go about doing it. Money Matters has a number of programs. They're always on the air. They come over on the air in one of the morning programs and in the afternoon, most days. And there's a public service announcement. And they have programs such as this, so you couldn't miss the effort that Money Matters has been doing to educate people about making wills and estate planning. And the public service announcement is very good, actually. So that if you don't know how to do it, I'm sure that if you call anybody at Money Matters, they will point you in the right direction. As I said before, you could go to a lawyer. If it's a simple will, you don't necessarily need a lawyer. There are forms of will that you will find on the internet. Some of the forms, I think one of the firms in the BVI used to do, I don't know if they still do it, they did wills on a pro bono basis. So that because it's so easy to do it. And it is cheap compared to the expense your relatives would have if you don't have one.